Okay. Good afternoon, ladies and gentlemen. I'd like to tell my personal experience recently, and I also intend to tell because it may enable us a little assuaged from the comparatively complicated nature of common law on real property. Have any experience to receive a strenuous offer from the car dealers or other sales agents of modern device? For example, my brand new iPod or so. My propensity toward the new product is very feeble indeed, and I'm normally satisfied with necessities and a little more for my personal integrity. I now use a far outdated mode of old Sonata, and most of my clothes also go in the same way. I'm actually not a central planner or communist to give any of determination about the dynamics of economy. I also absolutely not minded to become a proponent of narrative on the fetishism of commodity as like the Marxist circle. But I'm occasionally dubious if there are any kind of moral utility from an allegedly brand new product. I wonder if we can be healthier if we are stripped of internet. At some time, a paper version of newspaper is felt more attractive than the internet version. But over the lapse of evolution of time, the internet turned to be an indispensable, and the non-internet user is now considered a contemporary barbarian. That kind of non-necessities and later indispensable cycle can be found in many of our commodities. For the time constraint, I'm unable to further about my personality, but I could not be definitive for many reasons whatsoever. It is really hard times that we can keep on our true being. How do you agree if I say that we may look back to our possibly lost egos in this contemporary society? Do you like to see Hollywood movies or are forced to have your leisure time at given circumstances? As Keynesian economy suggests, supply can create its own demands. We now see the decades of economic crisis as worst ever since the Great Depression around 1930s. What do you think if there is any reason for this problem? Of course, we are not a student of economics and hardly get in as in a professional way. But for our humanly defense, I like to suggest one of personal attitudes with Professor Gosoma, where we can be a critic of our civilization in our routine days. For the background, I like to show the picture economist. I say, but I forgot to bring my USB, so that will be for next time. Instead, I like that you know that Professor Samrang recently published a book dealing with the Korean context. It is titled Some Optimist Observation on a Daily Basis, published in 2009 through 2012. He actively engaged in many areas of civilization criticism, and he also tried to combine the Western civilization with the Asian mode of capitalism. So he's a prominent scholar about the circumstances we are now facing in this contemporary Korea. And I like to continue on the acquisition of personal property. I prepared a chart to show a summary of rules about the acquisition of personal property, but as I said, I forgot to bring my USB, so that will be available also for next time. As in the case of South Korea, the personal property right may be a partial, that could be of ramification nature. We have two kinds of personal property right in the law of Korea. One is the right to possess until the death accrued from that a specific property, the relationship of which arises from the statutory ground. The other is said to be a bailment, but I'm not sure if this word exactly pertaining to the kind of right stipulated in Korea. It might be more analogous to the concept of possession or possessory interest, but I like to say initially as bailment. So it is similar, but in limited scope to the U.S. case, where express and implied agreements are eminent to find the bailments. But in some cases, bailments in U.S. would occur in the same, like the fourth statutory one of South Korea. Further, the bailments in U.S. may sometimes refer to the context of a possessory interest. The key concept in U.S. bailments are deposit of personal property of one person with another, usually for a particular purpose and under some sort of an agreement. In the U.S. law, a bailment is a legally recognized property relationship arising from the deposit of personal property of one person with another. As I said, usually for a particular purpose and under some sort of an agreement. The agreement may be written or oral and may be either gratuitous or for consideration. The most significant characteristic of bailment is that although title to the veiled chattel remains in the bailer, the bailee becomes entitled possession of the chattel on the terms and conditions of the bailment agreement. A bailment cannot exist unless the bailee knows that he has possession of a chattel belonging to another. Until such time as one is put on notice that he is being given or has acquired possession of the chattels of another, no bailment exists, and he cannot be held to the duties and liabilities of a bailee. In a case titled Parking Management Incorporation versus Gilder, decided in 1975 in District of Columbia, the court held that the parking of a car in a self-service area supervised by an informed employee creates a bailment or reasonable expectation of protection. In a few situations, even where there is clearly no express or implied agreement between the parties, the law will imply a bailment, usually in order to impose upon one of the parties the duties of a bailee. There is some situation that we can find the constructive bailee, where one party acquires possession of the chattel of another through trickery or fraud. The acquiring party may be held to be a constructive bailee and therefore be held liable for failing to exercise due care to preserve the chattel. One who finds lost property that he knows belongs to another is also classed as a constructive bailee. And the court knows an involuntary bailee, where the owner of a chattel accidentally lives with another, who subsequently discovers the possession thereof. The other person is said to be an involuntary bailee. In the case titled Shamrock Hilton Hotel versus a Coroner's, decided in 1972, Texas, the court applied an involuntary bailee and bailer rule. In the case, the guest of hotel who unintentionally left his purse in his hotel room could be an involuntary bailer, while the hotel is considered a bailee at the time when the lost or misplaced purse was delivered to and accepted by the cashier. So you can know that the law of bailments could be approximated to the law of possessory interest in Korea in many aspects. In comparison to Article 249 of Korean Civil Code, the U.S. law recognizes a bona fide purchase rule. Before that, we have to review some more about bailee's rights and interest in bail chattel. The title to a bail chattel remains in the bailer, and the bailee acquires only the right possession. Until the chattel is actually delivered to the bailee by the bailer has no rights in the chattel itself. The most the bailee would be a cause of action for damages against the bailer if the bailer refused to deliver the chattel in accordance with the terms of the bailment contract. If, however, the bailment were gratuitous, the bailee would have no cause of action for damages unless the facts established a promissory estoppel. Once the chattel is delivered to the bailee, he has the right to the exclusive use and control of the chattel during the term of the bailment, as long as his possession is consistent with the conditions of the bailment. The bailee can assert his right to possession against the entire world during the term of the bailment. Further, the bailee can maintain an action for conversion or for damages even against the bailer. If the bailer wrongfully interferes with the bailee's use of the chattel during the term of bailment, the bailee's right to possession also carries with it the right to recover the full value of the chattel. The third person can maintain an action in his own name against any third person who damages, injures, or destroys chattel, and can recover the total value of the chattel, irrespective of the value of his interest therein, and also irrespective of whether or not he is liable to the bearer. to the bailiff. The right to the exclusive possession of the bail chattel carries with it the right to the exclusive possession of all accretions, issues, and profits flowing from the chattel during the term. For example, the bail is entitled to possession of the offspring of bailed livestock, dividends on bail shares of stock, and so forth, for as long as the bailment lasts. All ordinary bail chattels are not subject to execution by creditors of the bailey. Since the bailey does not have title to the chattels, they are not liable for his death. However, if the bailment itself is of some value, the bailey's creditors can execute upon the bailey's interest. If they do, they acquire the right to use the chattel subject to terms and conditions of the bailment agreement. But there is an exception. If the terms of the bailment agreement or the nature of chattel itself would prohibit use by any but the original bailey, it is ordinarily held that the bailey's creditors cannot reach the bailment interest. The type and extent of use permitted must be determined from the bailment agreement. Any use must be fair and reasonable and within the scope of use permitted in the agreement. Any substantial abuse or misuse is a breach of the bailment and may subject the bailey to damages or may operate to terminate the bailment. The bailey owes the bailiff only the duty to exercise reasonable care under the circumstances to protect and preserve the bail goods, together with any other special duties provided in the bailment contract. A bailey is not entitled to any compensation for services or expenses in keeping or using the goods or for minor repairs which are merely incidental to use of the bail chattel. However, the bailey is entitled to compensation for actual expenses reasonably necessary to protect or preserve the chattel and not caused by any improper use of the chattel by the bailey. The parties may not entirely disclaim the fundamental obligations of good faith, diligence, and reasonable care that the bailey owes with respect to the bail chattels, but they can agree to limit the bailey's liability to reasonable standards, as accorded with the UCC 11023. Although a bailey is held only to standard of reasonable care with respect to protection and preservation of the chattel, is absolutely liable for improperly delivering the bail chattel to someone other than the bailiff. Such misdelivery is a breach of the bailment contract and constitutes a conversion of the bail chattel. Liability is absolute and not based on negligence. If the bailment is for a specified period, the bailey's right to possession continues until the expiration of the period, when the right to possession automatically reverts to the bailiff. If the bailment is at will, the bailiff can at any time terminate the bailment and end the bailey's right to possession. In either case, the bailey is obligated to make redelivery to the bailiff within a reasonable time. Detention by the bailey is a violation of the bailment agreement and is also a conversion of the bailiff's property, which subjects the bailey to damages accordingly. And like Korea, the U.S. law recognizes a bona fide purchase rule. A bona fide purchase in the U.S. context The person who, in good faith, purchased property for value without notice, expressed or implied, or any defect in the seller's title to the property. Generally, the equitable interest of a lien holder in personal property will be cut off by a bona fide purchase from the party in possession, unless the interest is protected by statute. This rule is contained in the Uniform Commercial Code, Section 2403, which has been adopted in all the states. This, therefore, you could find in the section that the UCC gives a merchant who deals in goods of the kind a power to transfer all rights to goods entrusted to the merchant. In order to establish the bona fide purchase, the Korean Code requires 5 elements, where the purchase should be open, notorious for value, without notice of defect, and finally with no negligence. These 5 elements are satisfied. The code normally finds it a bona fide purchase. And that operates to cut off any claims from the party in possession, unless the interest is protected by statute. In the case titled Porter versus Wars, decided in 1981, the court ruled the equitable estoppel does not apply to bar recovery by the true owner when the purchase did not make inquiries necessary in the circumstances about the seller's authority to sell. And in the United States context, there are 2 types of estoppels. One is a statutory estoppel, and the other is a equitable estoppel. A statutory estoppel, as found in Section 2403 of the UCC, does not protect the feign, in the case a Porter Wars. Feign is a defendant who was in the business of buying and selling art, and the case involved some art transactions with filmmaker. In that case, a feign was not a buyer in the ordinary course of business, and a Wars, who was also a defendant, sell Wars sold the uranium to other different feign. Eventually, the painting ended up in Venezuela, and Porter P. Issued 2 defendants jointly. Porter, who was a plaintiff, had several art transactions with filmmaker who used the name of Wars in business dealings. So, in this case, the court found the feign did not buy in a good faith because he failed to inquire into the history of ownership of the painting, although he could have done so easily. And the court considered if an equitable estoppel could be applied. Upon the court rulings, a good faith purchase may be protected by equitable estoppel, which exists prior to the UCC. This rule prevents an owner from setting up his own title as against the bona fide purchase of value when the owner clothes the vendor with possession and other indicia of title. So the judgment entered for a plaintiff on the issue of liability, and the case was remanded to assess damages. The court was not persuaded by a faint claim that the practice of trade did not require looking into a author's authority to sell the painting. Instead, it criticized such commercial indifference as facilitating the type of a conduct that occurred in this case. In the United States context, we can find several cases involving the transaction of art products, paintings, and for the later case, also we have the personal property issues involving the paintings. In some cases, a bona fide purchase cannot acquire title when a certificate requirement may intervene. In the case titled Sheridan Suzuki Incorporation versus Carusa Auto Sales, decided in the New York State in 1981, the court found a bona fide purchaser may not acquire title to vehicle when no certificate of title had been issued to the seller. It might not reach the property laws of Korea on the car. Automobile has an exactly same statute to be applied to the transfer of title of cars. One other point is the UCC rule, also the law of New York, the specific statute could conflict, but the court found that the more specific statute must prevail over the general UCC. UCC is a uniform commercial code adopted by almost all states in the United States. It was drafted by Caldwell and mostly be respected as one of successful work of law uniformity in the United States context. As in the same possession law in Korea, there is common law rule about unauthorized possession. But in the U.S., there is a spirit authority where the bare possession of property, though wrongfully obtained, is sufficient to enable the party in bare possession to maintain an action for reprieving or recovery of damages against a mere stranger who takes the property from him. In the case titled Anderson versus Goldberg, decided in Minnesota long ago, the year 1892, the court ruled that a plaintiff who acquired the logs as a trespasser may recover their value from defendant who subsequently took them from a plaintiff. However, in the case titled Russell versus Hill, decided in North Carolina, also long ago in 1900, the court found plaintiff may not recover against defendant for chattels defendant appropriated from a plaintiff, although title was in a third party. As you know, the Korean jurisdiction followed the first position. As in comparison to the Article 246 of a Korean Civil Code, the U.S. law normally adopted the rule on acquisition of title by adverse possession, where a party who is not the lawful owner of the property takes possession of it and maintains possession for the period prescribed by the statute of limitations in the local jurisdiction, and the lawful owner has failed to do anything sufficient to prevent the statute from running, the possessor becomes the owner of the property. The running of the statute operates to transfer ownership of the property to the adverse possessor. The statute period for adverse possession of personal property varies among jurisdictions, but frequently it is as little as 3 years. It is very short period as compared to the Korean Civil Code. We required 20 years for the immovables, and would be 10 years for the movables. Generally, the possession must be actual, open, notorious, hostile, unequivocal, continuous, apparent, and exclusive during the entire statutory period. In the case titled Shopping versus Freeland, decided in Massachusetts, 1886, the court found the prescribed time to suffice the adverse possession should be calculated on an accumulative basis in the case that the possession was delivered in sequence through the interest parties. Therefore, the court ruled that the adverse possession of a chattel for a period in excess of the appropriate statute of limitations prohibits the true owner from taking a possession of the chattel. In some cases, the statute of limitations and doctrine of adverse possession operates together. The statute of limitations normally set forth to bar recovery from the true owner upon the lapse of prescribed time. Practically, the issue frequently arises from the time for the statutory period to begin to run. In the case titled O'Keefe versus Snyder, decided in New Jersey, 1980, the trial court granted summary judgment for a defendant. But the appellate court reversed on the theory that a defendant had not proved the element of adverse possession, which was identical to the defense of a statute of limitations. In the trial court, the statute of limitations was 6 years, and the court found for defendant because plaintiff had not commenced the action within 6 years of the alleged theft. This case involves the theft of paintings. Georgia Coffey, who was a plaintiff, painted 3 small pictures which just disappeared from husband's gallery in 1946. He never reported the loss to the police or insurance company, and she did not advertise the loss. Long after the year, in 1975, plaintiff learned the paintings were on display, and in 1976, she discovered that Snyder, who was defendant, owned them. They refused the plaintiff's demand to return the paintings. Defendant claimed the person he bought them from had had them in his family since 1941 through 1943. So there is competing interest surrounding the true ownership. This kind of situation occurred recently in Netherlands, Holland. The paintings are drawn by a famous painters were stolen. They might be related with a later time when the allegation may be made about a true ownership and so. But in that case, there would be more a difficult problem because that may potentially involve an international context about it. So the jurors or arbitrators may have to find forcefully find an applicable statute by operation of a choice of law and others. Under New Jersey law, in this case, application of the statute of limitation is less clear. The discovery law prevents a cause of action from occurring until the owner discovered or should have discovered the facts which form the basis for the cause of action. To benefit from this rule, plaintiff must show she exercised due diligence to recover the painting at the time of loss. So the court imposed some of a practical elements to reinforce the statutory requirement. The court derived the element of due diligence that were not found in any of places of the statute a matter. In the court viewpoint, the elements are difficult to satisfy when personal property is involved. About adverse possession. The requirements of visible, open, and notorious possession is met, if at all, only with difficulty. The doctrine of adverse possession is not a reasonable response to personal property cases. Instead, the court must focus on the owner's diligence in seeking the lost property and apply the statute of limitations from the time the owner has or should have discovered where the property is. Do you agree to the reasoning of the court? Both provisions are an independent cause of action. On the other hand, one rights could be asserted to bar recovery from the true owner if the adverse possession was not proven. Very tricky, and it could be circular in logic between two systems. Interestingly, the court required due diligence of true owner in seeking the lost property and apply the statute of limitations. Compare with the dissenting opinion that the court dissenting position that the 6-year limitation period should apply from the date of cause of action. Peace cause of action against defendant arose when the defendant tortuously refused to return the painting to plaintiff upon her demand. So from the dissenting position, it is irrelevant whether the true owner exercised the due diligence to recover the lost property. The expiration of the statute of limitations has the effect of extinguishing legal title because the owner has no legal means of regaining a possession. To correspond with the rules specified in the Article 100 of Korean Civil Code, the U.S. law developed the law of acquisition of ownership by accession. Accession may be made by the labor of acceding party. The dispute could arise when the accession was not applied to the property of acceding party, and the increased property in value may be claimed by the true owner of original party. The court may go either way, and if the court failed to find the property right for the acceder, then the compensation could be made for the increase of property according to its value. In the context of United States law, accession denotes the improvement or augmentation of personal property by artificial means and involves problems as to ownership and damages where the personal property of one person has been improved or increased in value through the labor or materials of another. Where someone other than the owner of a chattel has taken it and augmented or increased its value will depend both upon the nature of taking and the value of the improvement. If the taking and trespass were willful, fraudulent, as force, it is almost uniformly held that the trespasser acquires no title. The owner of the property is entitled to all increment and augmentation to the property, even where there has been a change in its form or identity. Why is that so? To allow the trespasser to acquire title would allow him to obtain a right through his own wrong and would encourage plundering of the property of others. There would be a situation involving an innocent taking. The mere fact, in that case, the mere fact that an unauthorized person has innocently and mistakenly taken the owner's property and bestowed expense or labor upon it does not in itself deprive the owner of his property. However, where the innocent wrongdoer has made a substantial expenditure of labor or materials on the property and has thereby greatly increased its relative value, the innocent wrongdoer may acquire title depending upon the circumstances. Title may pass to an innocent trespasser when there is a great disparity in value between the original article and the new product resulting from the trespasser's labor or materials. The rationale is the substantial equity is served. The owner, however, retains the cause of action for damages. The question of what is the sufficient increase in value rests in the sound discretion of the court as to whether permitting the original owner to retain title to the improved property would be a gross and apparent injustice. The first case, title Weatherby versus Green, decided in Michigan long ago, the year 1871. Denied the claim of title for accession. The court found the plaintiff should not be allowed to replenish his property, which defendant, in good faith, obtained and converted into a chattel of much greater value. in that case, Weatherby, who was defendant, received permission to cut a certain trees from a party he believed owned them. After cutting the trees, defendant made the lumber into hoops. Then Green, who was plaintiff, the true owner of the trees, sold to replace the hoops. The standing number was worth $25, and the hoops were worth $700. There is a sharp contrast between the price before the accession and that after the accession. So the court gave a great statement to be very relevant with resolution of the case, this kind of case issues for the following cases. In the redress of private injuries, the law aims to compensate the injured, not penalize the wrongdoer. If plaintiff were allowed to replace the hoops, it would cause great injury to defendant and would overcompensate a plaintiff. For the second case, the court denied compensation where increase in value is so minor, insubstantial. The court found the plaintiffs may not recover the value of labor mistakenly employed to increase the value of a defendant's goods. The number would be $2.83 on one hand and $1.87 on the other hand. Plaintiffs may not recover. There is no great disparity between the value of the standing wood and the value of the wood chopped and stacked. It would be inequitable, according to the court opinion, to allow trespassers to recover for benefits they bestowed that are not substantial. In contrast, the court, in case titled Hardy versus Burrow, decided also in Michigan, 1973. Ironically, 3 cases came from the Michigan State, the jurisdiction of Michigan. In the last case, the court granted that a plaintiff may recover the value of a home built by innocent mistake on property owned by defendant. This case involves a home, relatively a good of high price. In this case, Hardy was plaintiff, mistakenly constructed a house on land owned by borough. Was defendant. It was subject to an outstanding land contract, and Tangible, also a defendant. Tangible took possession of the house and continued to occupy. The value of the house was $1,250. There was no evidence of fraud or of knowledge by a defendant of a plaintiff seller. Where the innocent trespasser transforms the property into an article of a newspaper so that the identity is lost, title will pass to the trespasser. The owner of the original property is relegated to a cause of action for damages. There is no clear law as to what constitutes a change of identity or species. The crucial issue is whether the property can still be identified in its original form. In all three cases, you need to know that the basic point of consideration, as I've said, the balance of private injuries between the and a true owner. You need to know that the civil justice has to be made distinctive from a criminal penalty. Although the United States still maintains the punitive damages, the law of punitive damages. It is one of a subject that is open to international criticism. Therefore, as in the opinion code, in the redress of private injuries, you have to focus on the adequate compensation between the involved parties. Not the imposition of a criminal sanction against the wrongdoer. Of course, the owner elects to seek damages. Where the situation allows the kind of remedy. Let's see. Where the taking and trespass were willful and wrongful, the owner elects to sue the trespasser for damages for conversion. The full market value of property in its improved state can be recovered. Where the trespass was inadvertent, the owner of the property may elect to sue for damages for the taking rather than to recover the chattel. Or the owner may be forced to do so because the substantial improvements made by the trespasser entitle the trespasser to ownership. In either case, the general view is that the measure of damages recoverable by the owner is the value of the property before its enhancement. Thus, the innocent trespasser is given credit for the increase in value due to his own labor and materials. But also, you need to know a trespasser has no cause of action where owner has recovered the property. Where the owner has already recovered the property from the trespasser has no cause of action for damages against the owner. This is true whether the trespasser was intentional or innocent, and regardless of whether the improvements made by the trespasser were great or small in value. The rationale behind this rule is that to allow otherwise would encourage carelessness and blunders. And in the civil law system, there is no need to have an independent review of a gift apart from the general theory of transfer of movables and immovables. But in the common law context, the rule of acquisition of ownership by gift could have some of a distinct elements, principally because a gift is made without a consideration in a common law context. In definition, a gift is defined as a voluntary transfer of property without consideration. And the common law contract requires a consideration must exist to find a valid contract, normally, with some exceptions from the modern rules. The concept of inter vivos gifts through this area of law, very powerful through this area of law. To find inter vivos gifts, there are three requirements for an effective transfer of ownership by it. First, a donative intent, delivery, and acceptance of the gift. Unless all are present, no effective gift can be made. Let's see the first element. The donor must have the mental capacity and must presently intend to make an effective gift. It is donor's subjective intent which is determinative. This is usually determined by the donor's outward manifestation, to say, statements and conduct, both at the time of the gift and later. And there must be a delivery. The donor must take some act by which he gives up the dominion and control of the property to the donee. The type of act required depends on whether the chattel is tangible or intangible. In the case of tangible chattels, as a general rule, physical delivery of possession is required for a gift of tangible chattels for a gift of tangible chattels to be varied. Mere words without a physical delivery are not enough. But we have an exception. By the weight of authority, a previous and continued possession in the donee dispenses with the requirement for any formal delivery. And most courts regard a written conveyance as better evidence of donative intent than mere delivery, and deem such a conveyance equally likely to protect the donor against rash gifts. Therefore, the majority view is that a written conveyance will sustain a gift in lieu of a physical delivery. Although actual physical delivery of intangible interest is, of course, impossible, courts require an act to serve as evidence of the donative intent of the donor and to protect against rash gifts. Oral words of gift are not enough. Therefore, the court developed a rule about a symbolic or constructive delivery, where the intangible interest has any token or symbol, for example, stock certificate, a bank account, passport, and so forth. The courts will recognize a delivery of the token or symbol as a symbolic or constructive delivery of the intangible interest. And in case of intangible chattels, a written conveyance of the interest is usually sufficient. In the Cohn case, decided in 1919 in the state of New York, the gift of a stock was given where a physical delivery is inconvenient. Under those circumstances, the court found that a varied vivos a gift was made. In giving a gift of a stock where physical delivery is inconvenient, but where a signed writing is delivered in the presence of witness and clearly expresses the intent of donor, a varied gift, it must be found that a varied gift has been completed. Let us consider the case named Gruen versus Gruen, decided in New York State also in 1986. In that case, the court held that a donor may make a valid interviewer's gift of chattel if the donor retains a life estate in the chattel and never surrenders a possession to the donee before the donor's death. This case also involves the painting, givings of paintings. Gruen was a plaintiff in this case, and as you surmise, the other Gruen is the father of Gruen. Gruen was a plaintiff, was a college student. And his father wrote him a letter telling him he was giving plaintiff a Klimt painting for his birthday. previously we have experienced several occasions involving the high-priced paintings in South Korea, and we gave suspicion about some of a corruptive plot involving the paintings. Pete's father stated he would retain possession for his lifetime, however. For tax reasons, a plaintiff's father later sent another letter describing the gift without referring to the life estate. Plaintiff's father also asked that plaintiff destroy the fourth letter, which plaintiff did. When plaintiff's father died 17 years later, the painting was still in the possession of Gruet, a plaintiff's stepmother. Oh, the defendant is a plaintiff's stepmother. I misread the paper, sorry. Pierre never had physical possession of the painting, and defendant refused the plaintiff's request but possession of the painting, and plaintiff sued. The trial court found that the elements of an interviewer's gift were not satisfied, and that the donor cannot retain a possessory life estate after purportedly giving personal property to another. The appellate court reversed, and on remand, the trial court awarded plaintiff $2.6 million, which was the value of the painting. The court articulated three elements of interviewer's gift, as we have reviewed formerly. In this case, the court ruled that an interviewer's gift differs from a testamentary disposition, which is an intent to make a transfer only upon the donor's death. The crucial test is whether the donor intended the gift to transfer present interest or intended the gift to have no effect until after the donor died. And once an interviewer's gift is made, it is irrevocable and title vests immediately in the donee. The element of delivery may be satisfied by constructive delivery, depending on the circumstances. So it is a crucial concept to see the operation of this area of law. There are many cases involving the constructive nature of a delivery. And in this case, the court also found that the acceptance element may be satisfied by the presumption that the recipient accepts a gift of value. And also, the court added, in this case, a plaintiff he showed that he had told others about the gift, and he kept the second letter for over 17 years to verify the gift. In this case, you need to make a point that the actual delivery had not long been completed until 17 years when the donor died. If that case was raised in the civil law system, the statute of limitations may intervene to bar the performance of a gift contract. But as we reviewed, the common law court developed the concept of a constructive delivery to test the interviewer's gift. You also need to distinguish from a testamentary disposition, as you can see in the court opinion. And we now turn to see a gift causal Moses. It is Latin word. In modern English, it may be translated gifts in contemplation of death. A gift causal mortis is one that is motivated by the prospect of imminent death. Such gifts are not regarded with favor in the law because they operate in contravention of the general rules for testamentary disposition of property. Accordingly, a purported gift causa mortis will be set aside unless its validity is shown by clear and convincing evidence. Although in order for there to be a gift causa mortis, the donor must have a distinct frame of mind. In other words, the contemplation of death. The basic donative intent is the same as the required in inter vivos gifts. In other words, no gift causa mortis can be made unless the donor intends an immediate present transfer of ownership. If the donor intends only that the gift be effective upon the donor's death, it is violative of statute of wills and ineffective either as an inter vivos gift or a gift causa mortis. While there is little actual difference from inter vivos gifts in the requirement of delivery, courts are frequently stricter as to the delivery requirement. In other words, a greater quantum of evidence as to donative intent is necessary. Actual physical delivery or written conveyance are minimum requirements. In a few states, witnesses are required. Constructive or symbolic deliveries are usually held not sufficient to sustain a gift causa mortis. In some cases, the court approached from the contract concept to reject the argument on invariant testamentary disposition. In the case named a Forst versus Reyes, decided in 1955, the court ruled where an attempt is made to make a gift causa mortis and a note is delivered describing the property, but no physical delivery on the property is made. There is no varied a gift that has been accomplished. According to the court opinion, there must be an intent to make the gift in contemplation of death, a delivery of the gift, and the death of donor. In order to give any effect to the statute of wills, there must be an actual physical delivery of the gift property. And in the case named Scherer versus Highland, decided in 1977, the court found a constructive delivery may support a gift causa mortis if the evidence of intent is indisputable. This case was disposed under exceptional circumstances. Normally, a constructive delivery could not suffice the gift a causa mortis. Gift causa mortis. In this case, Wagner, who lived with a Scherer, was involved in a serious car accident which left a permanently disabled. And later, Wagner committed suicide, leaving 2 handwritten notes and a check endorsed in blank. From the accident, she received a settlement check, which amounted to $17,400. It is a large amount. And in the case, the court finds that there is sufficient evidence to establish an intent to give upon his death, her death. In the case in lieu estate of Michaels, decided in 1965 in Wisconsin, the court held where a joint account is opened without informing one of the joint tenants of the gift, an invalid testamentary disposition has not been made. Another type of joint bank account, sometimes referred to as a poor man's will, is a Totten Trust, named after Ruth Totten, decided in New York, 1904. The case held that when a person deposits his own money in his own name as trust for another, the deposit is not an irrevocable trust. Instead, it is a tentative trust that is revocable at will during the lifetime of the depositor. If the depositor dies before the beneficiary without having revoked the account, a presumption arises that an absolute trust was created as the balance in the account when the depositor died. The depositor also has the option of completing the gift while alive by some unequivocal act or declaration, such as delivery of the passbook or notice to the beneficiary. Many states have adopted a specific statute to address the issue raised by will substitutes. Now, we turn to explore the private interest in land. In order to understand the operation of ownership of immovables, we first have to get aware of the feudal heritage imposed by King Williams on the conquered land of England. The Western history could fairly affect the law of property, sharply distinguishable from other areas of common laws. You see the Wikipedia page of Korean version describing the personal history of a William the Conqueror. William, usually known as William the Conqueror and sometimes as William the Bastard, was the first king of England, reigning from 1066 until his death in 1087. Descended from Viking raiders, he had been a Duke of Normandy since 1035 under the title of William II. After a long struggle to establish his power, by 1060, his hold on Normandy was secure, and he launched the Norman conquest of England in 1066. The rest of his life was marked by struggle to consolidate his hold of England and its continental lands, and by difficulties with his eldest son. He was the only son of Robert I, Duke of Normandy, and son of Duke Richard II. His mother, Herbia, was daughter of a Fulbert Fales. Fulbert may have been tenor or in Balm. She was possibly a member of a ducal household, but did not marry Robert. Instead, she later married a Hurin de Conteville, with whom she had 2 sons. William was known to be born in 1027 or 1028 at Forres, Normandy, probably towards the end of the latter year. Normally, the Norman conquest of England is considered the Western civilization begin to take the modern forms in a European continent. Its influence was enormous, not the context of England, but considered very significant in many points of a consideration when we explore the Western history. Before we begin to review, I'd like to make some points of introduction. The estate system began in feudal times, but still underlies our property law. It is an entirely artificial way of thinking about ownership, known only to Anglo-American law. In 1066, William the Conqueror imposed on England a feudal system, and it is from this system that the law of real property developed. The key features of the feudal system could be a feudal ladder, feudal services, and feudal incidents. And for the study purpose, you may well assume that there was a never drastic change, unlike the case of France in the system of private interest in land, which could continue through the modern time with some of exceptions. There were actually no point of radical transformation in Anglo-American law, unlike the French Revolution and the codification of Napoleonic Code. Subsequently, the Code of Germany. That is, indeed, there are many of a complicated vestiges of law in real property inherited from the feudal England. And the centralization of power in the states of European continent enabled the unitary origin of land in terms of its ownership, easily being ascribed to the state. In the structure of Anglo-American real property law, however, due to the vestiges of a warrior nobility and a feudal hierarchy, the intermediate concept of land law may play a role as a substitute for the state in inferring the nature of real property right. Of course, the eventual origin for the land could be found in the king, equivalent of state in modern times. But the focus is the centralized nature as compared to the real property right of a European continent. And third, let's get to the third point. In general consideration, you need to know that the types of real property right are necessarily defined objectively, unlike the contractual relationship. That is because it is the right of exclusive nature claiming against all the others in the world, and thus should be uniform to facilitate its national administration in an orderly fashion. The types of estate then comes from the provision of code in the civil law tradition, while the current types of estate were set in rule by the common law judges already in medieval times in Anglo-American context. So, okay, time is up, and we now close the class. In the next class, we continue to review the historical development of the estate doctrine. It is essential to understand the complicated rules long developed through the common law system. And we might advance to the law on fee simple absolute and the life estate, and a fee simple determinant. Okay, thank you. That will be all.